All right, we're looking at the last couple little small articles here of the Constitution before we get to the amendments. The amendments are kind of fun because they're a lot more particular. So let's look at the articles here. Talking about death and debts, supremacy, and oaths. So let's look at this. All debt contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. So in other words, anybody that loaned money to the government would still pay them back, even though this Constitution changed things. They wanted to make sure that the United States still paid back the people it owed money to. So this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. So the Constitution is the supreme law of the land, and all the laws that they make because of the Constitution, through the Constitution, and that are constitutionally legal, and all the treaties that they make that are constitutionally legal, those are the supreme laws of the land. And the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding. So in other words, if a state passes a law, or if the state adds something to its constitution that doesn't agree with the United States Constitution, so it doesn't work with the U.S. Constitution, the U.S. Constitution is the supreme law of the land. So it doesn't matter. A state can't pass a law that goes against the Constitution because it's not really a law, because it just doesn't work. The supreme law of the land is the Constitution. So states have to do things that only agree with the Constitution. So that's how that works. The last one here in this article: senators and representatives before mentioned and members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. So everybody, senators, representatives, members of state legislatures, executive officers, judicial officers. So executive, this is all the governors. Here, all the judges of all the states, all these people have to be bound by oath to support the Constitution. So if you're elected an officer in the United States, whether a state officer or a federal officer, you must be bound by oath or affirmation to support the Constitution. It is in the Constitution that your job is to support it. You cannot be a representative or a state legislature or any of those things and try to destroy the Constitution. That's the way it goes. You are required to support the Constitution if you are elected. But no religious test shall ever be required as a qualification to any office of public trust under the United States. So it doesn't matter what religion you are. You don't have to be a particular religion. You don't have to have specific religious beliefs. But you do have to support the Constitution. You can't be destroying it. So that's the oath. Last one here, kind of a little tiny one. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. So, the Constitution says if we're going to run this Constitution, we need at least 9 states. If we can get 9 states, we'll start. We'll be the United States of America with 9 states. But we need at least 9. If we can't get 9, if there's going to be less than 9, then we're going to throw out the Constitution and try something else. So in the beginning, how many colonies were there? How many states? There were 13. So 4 of them could have decided not to join. There could have been 4 states that said, no, we don't really want to be part of the United States of America anymore, and that would have been fine. The other 9 states would have gone on to be the United States of America. But if they could only get 6 that wanted to be part of the United States of America and the other 7 didn't, then the Constitution was not in effect, and they'd have to start over and try something else. So at least 9 states had to pass it. All of them eventually did. There were some of the states that were a little bit slower about it. All 13 eventually joined, and now we've even have more states that have joined. We have 50. And in the end, this is done by unanimous consent of the states present on the 17th day of September in the year of our Lord, 1787. So this is 1787, quite a while after 1776. End of the the independence of the United States of America, the 12th. So it's the 12th year of the United States. In witness of thereof, we've subscribed our names. So these are all the people that were there, that represented the various different states. The various states that were there. That's the Constitution of the United States. We are going to go on to the amendments, but make sure you're taking good notes on this and taking good notes on the amendments, because you'll have some good tests and writing assignments coming up.